Welcome back to Uprising AI, where we decode the future of artificial intelligence, one game-changing story at a time. Today, we're diving into one of the most explosive legal battles in the history of AI, Disney and Universal versus Midjourney. Yes, Hollywood's biggest giants are officially suing one of the world's leading AI image generators. In this case, it could reshape everything, from how AI is trained to how you're allowed to use it. Let's break it all down. On June 11, 2025, Disney and Universal filed a landmark 110-page lawsuit in a Los Angeles federal court against Midjourney, one of the most popular AI-powered image generators today. The studios allege that Midjourney has built what they call a bottomless pit of plagiarism, producing endless unauthorized copies of copyrighted characters: Yoda wielding lightsabers, Elsa from Frozen, Minions, Darth Vader, Shrek, Toothless, Spider-Man, Homer Simpson, Iron Man, and many more. According to the complaint, users are easily able to generate near-perfect recreations of these iconic IPs simply by typing a few prompts into Midjourney's platform. Disney and Universal claim that Midjourney knowingly trained its AI models on copyrighted material scraped from the internet, without permission, licenses, or compensation. The lawsuit states, Midjourney's AI is a virtual vending machine of copyrighted characters. That is a powerful accusation, and one that could redefine the entire AI industry.
At the core of this lawsuit is a debate that's been brewing in AI circles for years: fair use versus copyright infringement. Midjourney, like many AI companies, trained its models by scraping billions of images from across the internet. They argue that this training process is transformative, meaning the AI isn't directly copying but learning general patterns, styles, and concepts. But Disney and Universal strongly disagree. They argue that Midjourney's outputs are not transformative at all, but instead, they directly copy highly recognizable characters, art styles, and intellectual properties. The studios also argue that Midjourney ignored multiple cease and desist requests and continues to allow users to generate infringing images, even encouraging it with community prompts and shared AI models. In legal terms, Disney and Universal are seeking monetary damages, permanent injunctions, and, importantly, a court-ordered requirement for Midjourney to install technological filters that block infringing outputs moving forward.
Now you might be thinking, haven't AI companies been sued before? Yes, but this case is different. Until now, most AI lawsuits have come from individual artists, photographers, and authors. This is the first time major Hollywood studios have directly entered the battlefield. And unlike some previous lawsuits that focused on training data alone, Disney and Universal are attacking both the training process and the AI outputs, meaning the images users generate are seen as the illegal reproductions themselves. This strategic move shifts the case away from fuzzy legal questions about how AI learns, and focuses instead on the crystal-clear reproduction of recognizable characters. If the courts side with Disney and Universal, this could set a historic precedent. AI companies may be legally forced to obtain licenses for training data and implement real-time content filters before allowing AI-generated outputs to reach users.
At this point, Midjourney has yet to issue an official legal response, but CEO David Holtz has previously acknowledged that Midjourney's model was trained on, quote, a big scrape of the internet. The likely defense will lean heavily on fair use doctrine, arguing that AI's model training is transformative, non-commercial at the dataset stage, and akin to technologies like Google Search or Google Books, both of which survived copyright challenges. However, critics argue that producing near-exact images of Elsa, Spider-Man, or Yoda feels far more like commercial replication than transformative learning. And as we enter the era of AI-generated video, something Midjourney plans to launch soon, the stakes for Hollywood IP holders become exponentially higher.
Make no mistake, this lawsuit could change everything. If Disney and Universal win, AI companies may be forced to negotiate licensing deals with content owners, artists, and studios before training their models. This could trigger massive changes to data acquisition practices, model training pipelines, commercial licensing models, and real-time AI content filtering systems. It could also accelerate the development of watermarking, attribution standards, and new regulations governing AI content creation. Some even speculate this case could trigger an industry-wide shift toward licensed AI models, where datasets are built exclusively from paid, cleared, or open-source content. And let's not forget, this lawsuit is part of a much larger copyright war unfolding globally. Authors have sued OpenAI. Artists have sued Stability AI. Music labels are suing AI music generators. News publishers are demanding licensing fees for training data. We are entering uncharted legal territory, where centuries-old copyright law is colliding headfirst with cutting-edge generative AI models. The big question is, can copyright law evolve fast enough to regulate AI, or will AI reshape the very meaning of intellectual property itself? So where does this leave us? This lawsuit between Disney, Universal, and Midjourney could set a legal domino effect with massive consequences, not just for AI companies, but for creators, artists, and consumers worldwide. What do you think? Is AI stealing, or is it simply remixing like humans have done for centuries? Drop your thoughts in the comments. Don't forget to like, subscribe, and hit that notification bell for more breaking updates on the world of AI, copyright, and the digital revolution. This is Uprising AI, and the future has already begun.